Now I need to warn you, this video may be a little long. I'm going to share with you now about the difference between release of lien and release of liability, and when a short sale or foreclosure may make more sense. Many people are afraid that the bank will come after and sue them for the balance of the loss they experience because of a short sale or foreclosure. The information I'm going to share with you right now is California specifics, so this is for California only and does not apply to the other states. But before I get into that, there's a few key points that we need to understand and be on the same page in order to move forward and understand exactly what I'm trying to tell you. First of all, a lender can agree to do a short sale but still sue you if the short sale is not handled correctly. Basically, there's a difference between a release of lien and a release of liability. A release of lien means that the bank is basically authorizing you to sell the home and is removing the mortgage from title on the property so that the new owner can basically take title to the property free and clear of all previous liens. This does not mean that you are released from financial liability associated with your mortgage. Now, a release of lien and liability allows you to sell the home and truly walk away from the home and the debt obligation. This means the bank cannot sue you. Based on the type of mortgage that you have, and in cases where you are liable for the balance, if it was a short sale or foreclosure, there is still a statute of limitations for 4 years, in which time the bank must sue you if they would like to obtain a judgment against you. If they do not sue you within that 4 years, they can no longer collect on that debt. They can no longer get a judgment for the balance of that debt. Now, as I'm sharing this information the next few minutes here, understand that your situation might be slightly different, but this will give you a general idea. And I'm not an attorney, so I can't give you specific advice for your situation, but I'm going to give you specific laws and understanding of the law so you can make a decision after talking to your own attorney. If after watching this video you have more questions for how this may affect you in your situation, I can give you better direction and more case law or specific state law to help you understand what protection the state does offer you. Again, I'm not an attorney, but this is just generalized information on California law, not legal advice. Now, as I mentioned, in a short sale or foreclosure, you may still be liable for the balance, but if it's done right, you can be free from all liability. Now, in foreclosure, you can't really choose the outcome because state law decides that. But in a short sale, there is room for negotiation, so even if you have a recourse loan, we may be able to negotiate a full release of liability and make it so the bank cannot have any recourse against you. First, let's go over the foreclosure laws in California that make your loan a non-recourse loan so you can determine if your mortgage is a non-recourse loan. According to the California Civil Code of Procedures Section 580D, if your home has a purchase money loan, now this means it's the original loan, you never refinanced, not even for a rate and term, and it's your primary residence and it's 1 to 4 units, then you are protected under the foreclosure laws in California that your mortgage holders, the first and second lenders, cannot sue you for the balance of the loss associated with the foreclosure. Now, if you're not protected under that rule because either it's not your primary residence or you've refinanced the home, you may be protected under the one action rule. California Civil Code of Procedures Section 726A specifically explains what rights and what options a lender has in pursuing the balance of the loan if they're going through the foreclosure process. Now, a lender can choose to take one action to recover money on a loan in California. They can choose to do a judicial foreclosure, except in the cases we just mentioned, such as your primary residence, purchase money, where you've never refinanced a loan. And if they do decide to do a judicial foreclosure, it usually will take them much longer than a trustee sale, which is the most common type of foreclosure in California. These judicial foreclosure also costs more money, and they don't typically go with a judicial foreclosure if the borrower does not have much assets. During the foreclosure process, they actually are obtaining a judgment against the borrower. Now, if the lender chooses not to take that action of doing a judicial foreclosure, they can choose another action, which is most common, which is the trustee sale. A trustee sale, also known as a non-judicial foreclosure, is about 99.99% of all California foreclosures. The bank is basically electing to forego the right to sue you for the balance, and instead is electing to auction off the property via a trustee sale as their only method of recourse or recovering money for that loan. But if there are 2 liens on the property and the first lien does a trustee sale, the second loan, if with a different lender, may have recourse options and may be able to sue you. So the advice that you hear that you should just let it foreclose because it's less liability for you, in many cases is not true at all. And recently, as of January 1st, 2011, California state law now includes short sales as one option that the bank can take. So if a first lender decides to do a short sale instead of a trustee sale or a judicial foreclosure, they can no longer sue you for the balance because they're taking their one action by accepting the short sale. However, second liens are not included in this law, and they still could possibly sue you if you use the wrong agent who doesn't know how to negotiate a full release of liability with that second lender. Unfortunately, because this law is so new, many sellers in the last couple of years were not protected by the California law, and if their agent was ignorant and didn't understand the difference between a release of lien and release of liability, they may have opened them up to more liability by doing a short sale than had they let the home foreclose. This is why it's so important to use an agent who understands the difference between a release of lien and release of liability and actually knows how to negotiate with the banks to get them what they want, so they're willing to release you of all liability, so you don't have the fear for the next 4 years that the banks may sue you for their loss. Now I'm going to share with you a couple things that we do in our office to protect our sellers by negotiating a settlement with the bank and getting a full release of liability when in many instances the typical agent or negotiator would not know how to get a full release of liability from that lender. First of all, we use case law, and we also use our knowledge of the bank's benefit of doing a short sale, that they'll get much more money with a short sale than with a foreclosure, as leverage to get the bank to accept the terms that are best for our seller. First of all, the case law that we typically refer to when we're trying to get a bank to release a homeowner of liability when there's a first and a second loan with the same bank is Simon versus Superior Court. This is 1992 case law in California. In this case, Bank of America was trying to sue a seller after they'd done a trustee sale. Now, Bank of America, as the first mortgage, executed a trustee sale and forego their option of suing the client by way of a judicial foreclosure. Now, since Bank of America had a second loan on the property, they were suing the seller on the basis of, we are suing as the second mortgage holder and not as the first mortgage. The judge ruled to clarify that 726A, the one action rule, that the lender can take one action per property, not one action per loan on the property, if it's one bank with two different loans. Now let me give you an example of how we use this case law of Simon versus Superior Court to protect our sellers. Recently we had a seller who had refinanced both her first and second mortgage with Bank of America. Now these are both cash out refinances, which typically would be considered recourse loans in California. The bank approved the short sale, but was only releasing the seller of liability for the first mortgage and was saying that they would not release liability for the second mortgage. What finally made them change their mind and give in and release the client of liability for that second mortgage was that case law explained to them clearly that if they foreclosed via trustee sale, instead of doing a short sale, that the first and second lender would both be wiped out, and the only recourse they would have would be the balance they get from a foreclosure. So the bank in the end did release the seller of all liability in that transaction. Now the second tactic that we use in getting a full release of liability is often used when we're in a position where there's no case law, and in all honesty, the same liability exists if the home forecloses than if they do a short sale. So how do we get the bank to change their mind in that case? Well, we use our knowledge of the bank's numbers of what they'll get with the short sale versus what they'll get with the foreclosure. We use that as leverage to get the first lender to allow the second lender to have more money so that they're satisfied with releasing the client of all liability associated with that property. And oftentimes it requires that we use lines such as, the client doesn't see any benefit in doing a short sale if the same liability exists with a foreclosure. So hopefully this has made it clear that even if you're in a situation where you feel like a foreclosure is a better option, there may be liability that you don't know about. In that case, how to use the specific laws and negotiation tactics to get the bank to release you of all liability by way of doing a short sale. This way you can ensure that banks do not sue you for the balance of the loans that is lost.